Good morning. Welcome to Unit 8 of English Communication. I'm Kavita Venugopal from PS Polytechnic. We are going to learn one of the most important rights which many of us are unaware of. We have learnt about many other rights. We learn right for education, we learn about many other social rights and many other rights. But this is one right which most of us are unaware of, and that is right to information in Karnataka. Right to information in Karnataka is one such right which many of us are unaware. So our academicians have planned to put this into your curriculum so that this important right we need to learn about it, and that is right to information in Karnataka. Now and then you'll be hearing or reading in paper about something called as RTI. This is right to information, and this right to information which is there in Karnataka is what we are going to learn now. The Right to Information Act or RTI is an act of the Parliament of India. So this is set by the Parliament of India to provide for setting out the practical regime of right to information for citizens, and replaces the erstwhile Freedom of Information Act 2002. The act applies to all states and union territories of India except the state of Jammu and Kashmir. So the Indian Parliament enacted this RTI and thus gave a very powerful tool to the citizens to get information from the government as a matter of right. So this is a powerful tool which is with a citizen to get information from the government. We need to know what is happening in the government. We need to know what is happening to our tax money, whatever is happening, whether the bureaucrats, whether the people who are working for us, people who are working in the government, whether they are utilizing their powers properly, whether all the tax money that we are paying, is it utilized for the proper usage. So for all this, to get the information about all this as a matter of right, we can use this, the right which is called as Right to Information Act, which is in short RTI. And the RTI is done, or it is enacted by the Parliament of India. But the state levels have their own set of RTIs which are done according to the requirements of that particular state. So the state level RTI acts were first successfully enacted by the state governments. The first to enact this was, not the first, in Karnataka it came in the year 2000. So the RTI which we are going to read now is that is Right to Information Act, which was done in the year 2000, and Goa enacted this in the year 1997. Rajasthan enacted this along with us in the year 2000. Tamil Nadu in the year 1997, Delhi in the year 2001, Maharashtra in the year 2002, Assam in the year 2002, Madhya Pradesh in the year 2003, and Jammu and Kashmir in the year 2004, and Haryana in the year 2005. So these are all some of the states wherein they have their own RTIs, and we are going to read now the Right to Information in Karnataka. The Right to Information Act which is there in Karnataka, which came into form in the year 2000. See, the most important thing of this lesson is the legal language and format. Note the legal language and format in the following document. It aims to be precise and eliminate ambiguity. The Right to Information Act, whatever we are going to read now, it is an extract. It is not that somebody else has written this. It is an extract, and so it is something that it is not somebody has written this. It is an extract, and so this is in the legal language. It is in the legal language because it is as it is that is written in the document, as it is that is written in the Parliament of India. So there is a lot of usage of the legal language in this lesson. The Karnataka Right to Information Act 2000. Now we are going to read the extract. See, be it enacted by the Karnataka State Legislature in the 51st year of the Republic of India as follows. So in the Karnataka State Legislature in the 51st year of the Republic, this is what is written. The short title and commencement. This act may be called the Karnataka Right to Information Act 2000. So the short title and how it is commenced is, so this is the Karnataka Right to Information Act which came into force in the year 2000. And definitions. Now we are going to read some of the important definitions. The definitions in this act, unless the context otherwise requires. So the definitions which are used in this act, the same words, it might be used otherwise somewhere else, but according to this act, these words have got these definitions. The first one is competent authority. The first definition is competent authority. Competent authority means head of the office or any officer or person as may be notified by the state government for the purpose of this act. So competent authority means he is the head of the office or any officer or person who is working in the office who is notified by the state government for the purpose of this act. That means he is the officer for the purpose of this act. His work is to look after the RTI. His work is to give the information for people who apply this RTI. So competent authority, most important definition. Competent authority means he is the head of the office. So he is a person who is the head of the office or any officer or person as may be notified by the state government. That is, he has been notified, he has been identified by the state government for only the purpose of this act. The next definition is information. Information means information relating to any matter in respect of the affairs of the administration or decisions of a public authority. Next, we have read right to information. What is the meaning of this word information? Right to information. Information ತಿಳ್ಕೊಳ್ಳೋದಕ್ಕೆ ನಮಗೆ ಹಕ್ಕು. ಹಾಗಾದರೆ ಇನ್ಫಾರ್ಮೇಷನ್ ಅಂದರೆ ಏನು? ಯಾವ ಥರದ ಇನ್ಫಾರ್ಮೇಷನ್ ನಾವು ತಿಳ್ಕೊಬೋದು? That is the definition. Information means information relating to any matter in respect of the affairs of the administration or decisions of a public authority. Affairs of the administration affairs ಬಗ್ಗೆ or decisions of a public authority a decision ಬಗ್ಗೆ ಅಂತ ಇರೋದು ವಿಷಯ. ಇನ್ಫಾರ್ಮೇಷನ್ ಅಂದರೆ ಇದು. ಹಾಗಾದರೆ ಈ ಪಬ್ಲಿಕ್ ಅಥಾರಿಟಿ ಅಂದರೆ ಯಾರು? Who is this public authority? Public authority means all officers of the state government including the Karnataka Public Service Commission. ಸೊ ಆಲ್ ಆಫೀಸಸ್, ಪಬ್ಲಿಕ್ ಅಥಾರಿಟಿ ಅಂದರೆ ಯಾರು? ಪಬ್ಲಿಕ್ ಅಥಾರಿಟಿ ಅಂದರೆ ಆಫೀಸ್ಗಳು. ಯಾವ ಆಫೀಸ್ಗಳು? ಆಲ್ ಆಫೀಸರ್ಸ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಕರ್ನಾಟಕ ಪಬ್ಲಿಕ್ ಸರ್ವಿಸ್ ಕಮಿಷನ್. ಸೊ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿಸ್ ಕಾರ್ಪೊರೇಷನ್ ಕರ್ನಾಟಕ ಪಬ್ಲಿಕ್ ಸರ್ವಿಸ್ ಕಮಿಷನ್, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದ್ಯಾಟ್ ಆಲ್ ಆಫೀಸರ್ಸ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಆ್ಯಂಡ್ ಆಲ್ ಲೋಕಲ್ ಅಥಾರಿಟೀಸ್, all authorities constituted by or under any act of the state legislature for the time being in force, a company, corporation, trust, society, any statutory or other authority, cooperative society or any organization or body funded, owned or controlled by the state government but does not include. Okay. So all local authorities ಅಂದರೆ all local offices, all authorities constituted by or under any act of the state legislature for the time being in force ಅಂತಂದರೆ all local offices or authorities and all offices which will be working under any act of the state legislature which is in force for the time being. ಆ ಸದ್ಯದ ಸಮಯದಲ್ಲಿ ಆ ಲೆಜಿಸ್ಲೇಚರ್ ಫೋರ್ಸಲ್ಲಿ ಇರೋ ಅಂಥ ಎಲ್ಲ ಆಫೀಸ್ಗಳು, ಆ್ಯಂಡ್ ದೆನ್ ಅ ಕಂಪನಿ, ಆ್ಯಂಡ್ ದೆನ್ ಅ ಕಾರ್ಪೊರೇಷನ್. ಕಾರ್ಪೊರೇಷನ್ ಮೀನ್ಸ್ an organization or a group of organizations that is recognized by law as a single unit. So corporation andre one organization athwa group of organizations that is recognized by law as a single unit. As a single unit it will be recognized by law. Such corporations. And statutory. Statutory means fixed by law. So that must be done by law. And cooperative society. Cooperative means owned or run by the people involved. Cooperative society and it will be owned and it will be run by those people who are involved, and the profits will be shared by them. That is cooperative society. And then so all such things. So all local authorities, all authorities constituted by or under any act, and then corporation, trust, society, all these comes under this heading public authority. But which are all the office that does not include offices of the central government. Offices which are owned or run by central government does not come under this act, because this act is only for the state government offices. And then any establishment of the armed forces or central paramilitary forces, any establishment which belongs to armed forces or central paramilitary forces, these offices will not come under the heading public authority. Any body or corporation owned or controlled by the central government, any body or any corporation which is owned or controlled by the central government, these will not come under this public authority. So public authority, what comes under public authority? All offices of the state government, which also includes Karnataka Public Service Commission, and all local authorities which will be under this act of any state legislature which will be at that present moment working, and any company, any corporation, trust, society, any statutory or other authority and cooperative society or organization or body, and which is funded or owned or controlled by state government. So all these offices comes under this public authority. So the three definitions we learnt, which is important to understand right to information, is we learnt about competent authority, we learnt about information, and we also learnt about public authority. So to understand this right to information, these three important definition. See, competent authority. Competent authority is the person who gives, what does he give? He gives information. So what is information is, we learnt. He gives information to applicant regarding any public authority. Public authority are all those offices. So any information about public authority is given any information. So this definition, information, is important. What kind of information we get? So that information regarding public authority will be given by the competent authority. So these three definitions are interrelated. So that is why these three definitions are important. Next, right to information means right of access to information from any public authority. So what is this totally? What do we mean by this right to information? That means access of information from any public authority. And how can we get this information? By obtaining certified copies of any records, by obtaining diskettes, floppies, or any other electronic mode, or through printouts where such information is stored in a computer or in any other device in such other manner as may be prescribed. So access to information and from any public authority. And how can we get this information is by obtaining certified copies of any records. Certified copies of the records and diskettes, floppies, and or any other electron. It can be saved in any of these modes. It can be saved in the form of a diskette, it can be saved in the form of a floppy, it can be saved as printouts or in any other format in a computer. So in any other manner as may be prescribed, if you get the information, that is, you can get it. And this word record, what does this word record means? Record includes any document, manuscript and file, any microfilm, microfiche and facsimile copy of a document. So what does this word record includes? Any kind of document, manuscript, that is handwritten manuscript, and file, any microfilm. Microfilm means a film used for storing written information on in print of very small size. So a film used for storing written information, and here it will be stored in a print of very small size. So that is a microfilm. And microfiche, so and facsimile copy of a document. So a microfiche, what do we mean by this microfiche? Microfiche is a card made of transparent film used to store printed information in miniaturized form. So it is a card and it will be made of a transparent film, and it will be print, and here on this information will be stored in a miniaturized form. And to read this card, a user places it under the lens of a reader machine. So to read this, you can't read it like that because the information will be stored in a very miniaturized form. So the user will have to keep it under a lens of a reader machine, which magnifies it greatly, and this machine will magnify it. The thinness and small size of the film enables it to be stored very easily and efficiently, allowing libraries, museums and businesses to increase their resource collection without the need for additional storage space. So because of its thinness of the size, many museums, libraries and business establishments will save information in the form of a microfiche. Similarly, microfilm is a film used for storing written information on in print of very small size. And facsimile, FACSIMILE is pronounced as facsimile. It is an exact copy of something. It is similar to a fax. So the information might be stored in any of these formats. You are enabled to get this kind of information. And any reproduction of image or images embodied in such microfilm, whether enlarged or not, you might get the information. And any other materials produced by a computer or by any other device. So if record means all this information stored in any of these formats, a person has got that authority to get the information from the competent authority who is working in the precise public authority. And trade secret, you cannot get the information about trade secret. What does this trade secret means? Trade secret means information contained in a formula, pattern, compilation, program, device, product, method or technique or process which is not generally known and which may have economic value. So trade secret, some of the trade secrets is not possible to be known by the person who wants to know the information. If you apply for RTI stating that I need to know the trade secret of the product, it is not possible for you to know. So what does this trade secret means? Information contained in a formula, some information about a formula or about a pattern or about the compilation of something or about any program or any information about any device or any information about any product or method or techniques or process of preparation of something. If you ask all this which is not generally known to the public, such and which will have lot of economic value, such information will not be given to you. Next, obligation of public authorities. So this public authority means these offices, they have certain obligation. They need to have some obligation, that is they have some rules regarding this. Every public authority shall, what is his work? What is his work is maintain all records in such manner and form as is consistent with its operational requirements duly catalogued and indexed. Duly catalogued and indexed. They have to maintain records. In what form? They will have maintained records which is consistent. They'll maintain records, and which will be duly catalogued and indexed. Catalog means to record something, especially in a list, in a special order. In a special order, if you maintain any record, it is called as catalog. Indexed. Indexed means a list of names or maybe topics that are referred to in a book, etc., which will be arranged in alphabetical order. So that is indexed. So it should be neatly catalogued and it should be indexed. And the second duty for them is they have to publish at such intervals as may be prescribed. How should they do that? What should they publish is the particulars of its organization, functions and duties. And second point, the powers and duties of officers and employees and the procedure followed by them in the decision making process. So these are all the obligation of the public authorities. They have to the particulars of its organization, its functions and duties, they'll have to publish it. And the powers and duties of officers, all this has to be published at equal intervals. And the norms set up by the public authority for the discharge of its functions. There will be certain norms set up by the public authority for the discharge of its function. So they will have to publish it whenever possible, whenever it is prescribed, at intervals as may be prescribed. And then the details of facilities available to citizens for obtaining information. So the details of the facilities which is available for citizen to obtain this information, all these details come under the obligation of public authorities. They have to do all this work. They have to maintain all the records which is neatly catalogued and which is neatly indexed, and they have to publish all these information. So that is the obligation of public authority. And it continues, they also have to publish all relevant facts concerning such of the important decisions and policies that affect the public may be prescribed while announcing such decisions and policies. They have to publish all relevant facts, the facts which is important or important decisions and policies that will affect the public while announcing such be prescribed while announcing such decisions and policies. And before sanctioning or initiating or causing to sanction or initiate any project, scheme or activity as may be specified by the state government, publish or communicate to the public generally or to the persons affected or likely to be affected by the project, scheme or activity in particular in such manner as may be prescribed, the facts available to it or to which it has reasonable access, which in its opinion should be known to them in the best interest of maintenance of democratic principles. The meaning of this whole paragraph is, before sanctioning or initiating any project, see the government will have any projects. Before sanctioning a project or before starting, initiating means starting any project or a scheme or any activity by the state government, they have to publish it in the, they have to publish it or they have to communicate to the public. They have to publish or they have to inform it to the public. Generally, public in general or to the persons who are affected by this or who are likely to be affected by their projects. ಯಾವುದೋ ಒಂದು ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡಿದಾಗ ಯಾರಿಗಾದ್ರೂ ಒಂದಷ್ಟು ಜನಕ್ಕೆ ಇದರಿಂದ ಅಫೆಕ್ಟ್ ಆಗತ್ತೆ ಅಂದರೆ ಅವ್ರಿಗೆ ಇವರು ಮುಂಚೆನೇ ಇದನ್ನು ತಿಳಿಸಿರಬೇಕು. ಯಾವುದಾದ್ರೂ particularly in such manner as may be prescribed, the facts available to it or to which it has reasonable access. So the facts which is available or which has reasonable access with in its opinion should be known to them at the best interest of maintenance of democratic principles. To maintain democratic principles, before sanctioning or initiating any project, the people who are concerned should know about this. So, that is the obligation of the public authority. These are all the work which the public authority, the office, will have to do. These are all their obligations. The next important thing which you have to learn is procedure for supply of information. So, now you need to get any information. So, you need to apply for the RTI. What is the procedure for that? For the supply of information, how can you get this information? This is one very important question. Procedure for supply of information. What is the procedure they follow to supply this information? A person desirous to obtain information shall make an application to the competent authority in the prescribed manner, along with such fee, in such form, and with such particulars as may be prescribed, provided that the fee payable shall not exceed the actual cost of supplying information. So, a person who is desirous to obtain information, what will he do? He will write an application. He shall make an application to the competent authority. Competent authority means that officer who is responsible. So, for that officer, he will write an application in the prescribed manner. Prescribed manner, it is an idiom. Authority in the prescribed manner. Prescribed manner ಅಂದರೆ ಇದೇ ರೀತಿ ಬರೀಬೇಕು ಅಂತ, ಯಾವುದೋ ಒಂದು ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಆಗಿರೋ ಮ್ಯಾನರ್ ಇರುತ್ತೆ, ಅದೇ ಥರನೇ ಅಪ್ಲಿಕೇಶನ್ನ ಬರೀಬೇಕು. ಇನ್ ದಿ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಮ್ಯಾನರ್ ಅಲಾಂಗ್ ವಿತ್ ಸಚ್ ಫೀ ಆ್ಯಂಡ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಪೇ ಸಮ್ ಫೀಸ್ ಇನ್ ಸಚ್ ಫಾರ್ಮ್ ಆ್ಯಂಡ್ ವಿತ್ ಸಚ್ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಆ್ಯಸ್ ಮೇ ಬಿ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್. ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿರೋಂಥ ಫೀ, ಆಮೇಲೆ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿರೋಂಥ ಫಾರ್ಮ್, ಆಮೇಲೆ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿರೋಂಥ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್, ಇದೆಲ್ಲ ಕೊಟ್ಟು ನಾವು ಅಪ್ಲಿಕೇಶನ್ನ ಬರೀಬೇಕು. Provided that the fee payable shall not exceed the actual cost of supplying information, and the fee that is payable should not exceed the actual cost of supplying information. Whatever cost the person is going to acquire, and the fee payable should not be more. Whatever cost is acquired and the feeable, it will be equal, it will not be more than that. Next, on the receipt of an application requesting for information, the competent authority shall consider it and except for justifiable reasons pass orders thereon, either granting or refusing it as soon as practicable, and in any case within 15 working days from the date of receipt of the application. On the receipt of an application, that is, after you pay the fees and as you get the receipt, on the receipt of an application requesting for the information, the competent authority, what shall he do? He will consider it and except for justifiable reasons, some reasons for which he will have to justify, except for the justifiable reasons, he will pass order thereon, either granting it or refusing it as soon as practicable, and in any case within 15 working days from the date of receipt of the application. So, the person who applies for this will get the information within 15 working days from the date of receipt. That means since the date when you paid the fees, from that date within 15 working days you will get the answer for your information whatever you have seek from them. Next, provided that where the competent authority does not have the information, he shall within 15 days from the date of receipt of application transfer the application to the officer or person with whom such information is available and inform the applicant accordingly, and thereafter such officer or person to whom such application is transferred shall furnish information within 15 working days from the date of receipt of the application from the competent authority. If the competent authority does not have the information, he shall pass this to the person who has got this information. So, he shall within 15 days from the date of receipt of application transfer the application to the officer or person with whom such information is available. He will transfer it to the other person with whom this information is available, and the applicant accordingly and thereafter such officer or person to whom such application is transferred shall furnish information. So, the other person to whom this application is transferred, he will furnish information again within 15 working days. See, they will not say within 15 days, because the day when you applied the application, next there might be some 10 to 12 days of holidays. So, within 15 working days from the date of receipt of the application from the competent authority. So, you will get the information within 15 working days. Where a request is rejected under section 2, the competent authority shall communicate in writing to the person making the request. If your application is rejected under subsection 2, what the competent authority shall communicate and inform it to you in writing to the person who is making the request. He will write the reasons for such rejection. Why is your application rejected? And the period within which the appeal against such rejection may be preferred. You will have a chance to re-appeal. So, the period within which you will have to re-appeal, that will also be informed. And the particulars of the appellate authority, the particulars of to the person to whom you will have to appeal, all this will be given to you. So, that is the work of the competent authority. He shall communicate to you and he shall inform you about all these details. Grounds for refusal to supply information in certain cases. See, as you apply for the application, in certain cases they can reject your application, they can refuse to give you the information. So, what are all the grounds? When can they refuse this giving of information? So, that is grounds for refusal to supply information. That is, without prejudice to the provisions of section 4, the competent authority may also reject a request for supply of information without prejudice. Prejudice ಅಂತಂದ್ರೆ biasness, ಹೊಟ್ಟೆ ಕಿಚ್ಚಿರೋದು. They cannot reject your application because of prejudice. They need some proper grounds for that. May also reject a request for supply of information where such request, if your request is too general in nature and the information sought is of such nature that it is not required to be ordinarily collected by the public authority. If you are asking for some too general information, ಯಾವುದೋ ಒಂದು ಇನ್ಫಾರ್ಮೇಷನ್ನು ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಗೊತ್ತಿರೋ ಅಂಥದ್ದು ಅಥವಾ ಪೇಪರಲ್ಲಿ ಸುಮಾರು ಸತಿ ಪಬ್ಲಿಷ್ ಆಗಿರೋಂಥ ಇನ್ಫಾರ್ಮೇಷನ್ನಿನ ಬಗ್ಗೆ ನೀವೇನಾದರೂ ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಷನ್ ಆ್ಯಕ್ಟ್ ಮುಖಾಂತರ ಅದಕ್ಕೆ ತಿಳ್ಕೋಬೇಕು ಅಂತ ಹಾಕಿದರೆ, ದೆನ್ ದೇ ವಿಲ್ ರೆಫ್ಯೂಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಟೂ ಆರ್ಡಿನರಿಲಿ, it can be ordinarily collected without the help of the public authority. So, in that case they will refuse your application. Next, provided that where such request is rejected on the aforesaid ground, it shall be the duty of the competent authority to render help as far as possible to the person seeking information to reframe the request in such a manner as may facilitate the supply of information. Once he has rejected your application, it is also the duty of the competent authority that he must render help, he must give you help as far as possible to reframe the request. See, some of the question, the procedure in which you have written the question might not be proper, or you might not be asking the information in the proper method. Then he will give help to reframe the request which makes it easy for you to get the information, as may facilitate the supply of information, which makes it easy for the supply of information. So, this is also the work of the person, competent authority. So, they might refuse your request if it is too general, and then they might reject it if the information relates to information that is required by law, rules, regulations or orders to be published at a particular time. See, some of the rules, some of the laws, some of the regulations has to be published at one particular time. They cannot publish it whenever a person asks, and if your request is regarding any such rule or any such regulation, they cannot provide you the information when you ask it, because it has got certain time. They will have to give the information only at that time. So, they will not give such information. And if the question that you have asked relates to information that is contained in published material available to the public. So, or if you have asked about some information which is already published and it is in a published material available to the public, like something which is available in newspaper, something which is available in a magazine, something which is already there. If you are asking about any such information, they might refuse to give it. And then relates to personal information, the disclosure of which has no relationship to any public activity, or which would cause unwarranted invasion to the privacy of an individual, except where larger public interest is served by disclosure, provided that the information relating to returns of assets and liabilities filed by a government servant shall be made available to the public. If the information that you are seeking, it relates to some personal information of a personal information of a person, and the disclosing of that which has no relationship to any public activity. ಇದು ಯಾವ ಪಬ್ಲಿಕ್ ಆಕ್ಟಿವಿಟಿಗೂ ಸಂಬಂಧ ಪಡದೇ ಇರುವಂಥ ಯಾರೋ ಒಬ್ಬ ಮನುಷ್ಯನ ಪಬ್ಲಿಕ್ ಇನ್ಫಾರ್ಮೇಷನ್ನ ನೀವು ಪರ್ಸನಲ್ ಇನ್ಫಾರ್ಮೇಷನ್ನ ನೀವು ಕೇಳಿದ್ರೆ ಆ ಇನ್ಫಾರ್ಮೇಷನ್ನ ನಿಮಗೆ ಕೊಡೋದಿಲ್ಲ. ಯಾಕೆಂದರೆ ಇಟ್ ವಿಲ್ ಬಿ ಅನ್ವಾಂಟೆಡ್ ಇನ್ವೇಷನ್ ಆಫ್ ದ ಪ್ರೈವಸಿ ಆಫ್ ಎನ್ ಇಂಡಿವಿಜುವಲ್. ನಾವು ಅನ್ವಾರಂಟೆಡ್ ಅಂದರೆ ಹೇಳ್ದೆ ಕೇಳದೆ ಒಬ್ಬ ಪ್ರೈವಸಿ ಆಫ್ ಒಬ್ಬ ಮನುಷ್ಯನ ಪ್ರೈವಸಿನ ಇನ್ವೇಡ್ ಮಾಡ್ದಂಗೆ ಆಗತ್ತೆ, ಆಕ್ರಮಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಂಗೆ ಆಗತ್ತೆ. ಆದ್ದರಿಂದ ಅಂಥದನ್ನು ಕೊಡಲ್ಲ. ದೇ ವಿಲ್ ಗಿವ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಅಬೌಟ್ ಅ ಪರ್ಸನ್ ಇಫ್ ದಟ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಈಸ್ ಅಬೌಟ್ ದಿ ಅಸೆಟ್ಸ್ ಆ್ಯಂಡ್ ಲಯಬಿಲಿಟೀಸ್ ಫೌಲ್ಡ್ ಬೈ ಅನ್ ಗೌರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್. ಒಬ್ಬ ಮನುಷ್ಯನ ಅಸೆಟ್ಸ್ ಬಗ್ಗೆ ಅಥವಾ ಲಯಬಿಲಿಟೀಸ್ ಫೈಲ್ಡ್ ಬೈ ಅನ್ ಗೌರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್, ದಿಸ್ ವಿಲ್ ಬಿ ಮೇಡ್ available to the public. Penalties. Now, where any competent authority without any reasonable cause fails to supply information sought for within the period specified under section 5 or furnishes information which is false with regard to any material particulars and which it knows or has reasonable cause to believe it to be false. Okay, penalties. The competent authority, where any competent authority without any reasonable cause fails to supply information. So, if the competent authority, you have applied for the information, and if the competent authority without any reasonable cause, ಯಾವುದು ಸರಿಯಾದ ಕಾರಣ ಇಲ್ಲದೆ fails to supply information. See, there are some grounds to refuse information. If the information that you have sought and the public competent authority does not give you the information without any reasonable cause, ಏನು ಸರಿಯಾದ ಕಾರಣ ಇಲ್ಲದೆ if he fails to supply you the information within the period specified under section 5. So, period specified under section 5 is within 15 working days. Or furnishes information which is false, or if he gives information which is false with regard to any material particulars and which it knows or has reasonable cause to believe it to be false. ಯಾವುದಾದ್ರೂ ಫಾಲ್ಸ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಕೊಟ್ಟರೆ ಅಥವಾ ಎನಿ ಮೆಟೀರಿಯಲ್ ಆ್ಯಂಡ್ ವಿಚ್ ಯು ಫೀಲ್ ದಟ್ ಇಟ್ ಈಸ್ ಬಿಲೀವ್ ಟು ಬಿ ಫಾಲ್ಸ್, ಅಥವಾ ನಿಮಗೆ ಅದೇನಾದರೂ ಸುಳ್ಳು, ಇದು ಫಾಲ್ಸ್ ಇರಬಹುದು ಅಂತ ಅನಿಸಿದ್ರೆ, ದೆನ್ ಇನ್ ಆಲ್ ದೀಸ್ ಕೇಸಸ್ ದಿ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ ವಿಲ್ ಬಿ ಪೀನಲೈಸ್ಡ್. ಅಂದರೆ ಅವನಿಗೆ ಶಿಕ್ಷೆ ಕೊಡಲಾಗುತ್ತದೆ. ಅವನು ನಿಮಗೆ ನೀವು ಕೇಳಿದ ಇನ್ಫಾರ್ಮೇಷನ್ನ ಸರಿಯಾದ ಸಮಯದಲ್ಲಿ ಕೊಡದೇ ಇದ್ದರೆ. ನೆಕ್ಸ್ಟ್, ದಿ ಅಥಾರಿಟಿ immediately superior to the competent authority may impose a penalty not exceeding 2,000 rupees on such competent authority as it thinks appropriate after giving him a reasonable opportunity of being heard, and such a penalty shall be recoverable from his salary, or if no salary is drawn, as arrears of land revenue. Okay, so the person who is immediately superior to the competent authority, he may impose a penalty, he might impose him ಅಂದರೆ ಅವನಿಗೆ ಹಾಕ್ಬೋದು, ಪೆನಾಲ್ಟಿ ಹಾಕ್ಬೋದು. and that penalty is not exceeding 2,000 rupees, and that penalty should not exceed 2,000 rupees. so 2,000 rupees ಒಳಗೆ ಆ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ ಅವ್ರು ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮೇಷನ್ ಕೊಡಲಿಲ್ಲ ಅಂತಂದರೆ 2,000 rupees ಒಳಗೆ a person who is immediately superior to the competent authority might give him penalty, and so, as it thinks appropriate, as the person thinks appropriate. ಆ superior authority ಇರ್ತಾನಲ್ಲ ಅವನಿಗೆ ಸರಿ ಅನಿಸೋ ಥರ ಅವನು ಪೆನಾಲ್ಟಿನ ಹಾಕ್ತಾನೆ. as it thinks appropriate after giving him a reasonable opportunity of being heard. ಫಸ್ಟು ದೇ ಶುಡ್ ಗಿವ್ ಹಿಮ್ ಆಪರ್ಚುನಿಟಿ ಆಫ್ ಬೀಯಿಂಗ್ ಹರ್ಡ್. ಯಾಕೆ ಹಿಂಗೆ ಮಾಡಿದೆ, ನೀನು ಯಾಕೆ ಅವನಿಗೆ ಇನ್ಫಾರ್ಮೇಷನ್ ಕೊಡಲಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಅವನಿಗೆ ರೀಸನ್ಸ್ನ ಕೊಡೋದಕ್ಕೆ ಸಾಕಷ್ಟು ಸಮಯ ಕೊಡಬೇಕು. ಆ್ಯಂಡ್ ದೆನ್ ಹಿ ಶುಡ್ ಬಿ ಪೀನಲೈಸ್ಡ್, ಆ್ಯಂಡ್ ಸಚ್ ಅ ಪೆನಾಲ್ಟಿ ಶಾಲ್ ಬಿ ರಿಕವರಬಲ್ ಫ್ರಮ್ ಎ ಸ್ಯಾಲ್ರಿ. ಆಮೇಲೆ ಇಷ್ಟೆಲ್ಲ ಅವನಿಂದ ಎಲ್ಲ ಕೇಳಿಸ್ಕೊಂಡು ಆಮೇಲೆ ಅವನಿಗೆ ಪೆನಾಲ್ಟಿ ಹಾಕಿದ್ರೆ ಇಟ್ ಶುಡ್ ಬಿ ರಿಕವರಬಲ್ ಫ್ರಮ್ ಎ ಸ್ಯಾಲ್ರಿ. ಒಂದು ಸ್ಯಾಲ್ರಿಯಿಂದ ಇದನ್ನು ರಿಕವರ್ ಮಾಡೋ ಥರ ಅವರು ಮಾಡ್ಕೋತಾರೆ. ಆರ್ ಇಫ್ ನೋ ಸ್ಯಾಲ್ರಿ ಇಸ್ ಡ್ರಾನ್, ಅಥವಾ ಆ ಪರ್ಸನ್ ಏನಾದರೂ ಸ್ಯಾಲ್ರಿ ಡ್ರಾ ಮಾಡ್ತಿಲ್ಲ ಅಂದರೆ ಆ್ಯಸ್ ಅರಿಯರ್ಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ, ಇನ್ಯಾವುದಾದ್ರೂ ಮುಖಾಂತರ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಮುಖಾಂತರ, ಅಂದರೆ ಅವನ ಹತ್ರ ಇರೋ ಲ್ಯಾಂಡು, ಅದರಿಂದ ಯಾವುದಿಂದನಾದರೂ ಅವರು ಆ ದುಡ್ಡನ್ನು ಅವನಿಂದ ವಾಪಸ್ ತಗೋಬೋದು. He shall also be liable of disciplinary action under the service rules applicable to him, and he shall also be liable, he will also be able to get into disciplinary action. The person who is immediately superior to the competent authority might also take some disciplinary action against him under the service rules applicable to him. There is a rule called as service rules. Under the service rules he can also be penalized. He shall also be liable to disciplinary action under the service rules which is applicable to him. Service rules, there are different service rules. Whichever service rule is applicable to him, he might be penalized under that. Then bar of jurisdiction of courts. That means there is some bar of jurisdiction of courts. There are certain courts to talk about this, to talk about RTI. And what is that is, no court shall entertain any suit, application or other proceeding in respect of any order made under this act, and no such order shall be called in question otherwise than by way of an appeal under this act. No court shall entertain any suit. If you want to sue some person or anything like that, no court shall entertain any suit, application or other proceeding in respect of any order made under this act. Under this act, any order which is made, nobody can question that, or any or other proceeding in respect of any order made under this act, and no such order shall be called in question otherwise than by way of an appeal under this act. Nobody can question this whatever they have asked you for. So that is bar of jurisdiction of court. If they have given you an information, and when and no court will entertain such thing, or nobody can apply for any suit or application regarding this. So that is about RTI, right to information in Karnataka. So this particular rules, whatever we have read now, belongs to the RTI of Karnataka, right to information in Karnataka. See, we have read about this RTI, which is very important. People does not know that such a rule exists, such a right exists. If at all we know about this, we can exercise our duty, we can exercise our right, because we know the tax money that we are paying, all this, whether it is being utilized properly, we have the right to know about all these things. So whenever, it is very important for you to know the way in which you can apply for the application. What you'll have to, the procedure for supply of information is very important, because whenever you require, you need to know about the procedure of this supply. So what you have to do, a person who is desirous to ask for the RTI, if you have doubts regarding something, if you need to know whether your tax money is utilized properly, some work that is happening in your locality, if you have any doubts about that, you can apply for RTI, and you need to know the procedure, very important. That's why I am talking about this once again. The procedure for the supply of information is, you have to first write an application, and you have to write this application to the competent authority, and this application has to be written in the prescribed manner, whichever manner that is told. You can't write the application in whatever way you need to do. You have to write the application in the prescribed manner, and you will have to pay some fees, and that fees will not exceed the actual cost of the supply of information. So you will have to write the application and pay the fees, and as you pay the fees, as you get the receipt of the application, as you are getting the receipt of the application, whatever application you have given for request of information, the competent authority is the person who is notified by the state government for the purpose of this act. He is the competent authority. The work of that competent authority is to consider it, and without and except for justifiable reasons, the reasons that he can justify that, without these reasons he can't reject that. What he has to do, once he receives the application, he has to pass orders thereon, either granting or refusing it. Either he will have to grant your application, that means he has to give you the information, or he can refuse it. So first thing that he will have to do is his pass order, whether I am granting the request or whether he is refusing it. And as soon as practicable, in any case, within 15 working days, he has to give the information within 15 working days from the date of receipt of the application. Since the days when you have applied for the information, he has to give the information within 15 working days. And if the, provided that where the does not have the information, if the competent authority does not have the information, he shall, and even this he can't take months together, within 15 days from the date of receipt of application, he must transfer the application to the other person with whom such information is available. He has to transfer it to that person, and from thereafter, that other person to whom such application is transferred, he will have to furnish the information again within 15 working days. Within 15 working days from the receipt of the application, he has to, within 15 days, the day from which he has received the application, from there within 15 days he has to give you the information. And if he has rejected your application, he has to write in communication, he has to communicate to you why that application was rejected. He has to give the reasons for the rejection, and he has to he has to tell you how that application has to be written, all this has to be done by the competent authority. So this is one which very important thing which you need to know about the RTI. And then the obligation of public authorities, you have learnt about this. And then so the three important definitions which you need to know about this is competent authority, information and public authority. Let's just revise these definitions once again. So competent authority means he is the head of the office or any officer or person as may be notified by the state government for the purpose of this act. For the purpose of this act, whoever is responsible, he is known as the competent authority. And information, whatever information means any information relating to any matter in respect of the affairs of the administration or decisions of a public authority. Any information relating this, and this information can be stored in any form. It might be stored in the form of printed matter in a computer. It might be stored in the form of a facsimile copy. It might be stored in the form of a film. It might be stored in the form of a movie. It might be stored in the form of a microfiche. In any of these formats it has been stored. A person, it might be stored in the form of a diskette. In any of this form, this information will be stored. The person has the right to get the information. So that is information. And from where do you get this information? From the public authority. So what is public authority? All officers of the state government, which includes the Karnataka Public Service Commission and all the local authorities, all the companies, all the corporation, all this trust, all the society which is run or which is owned by the state government. We cannot get information about the central government officers or any officers which is related to paramilitary forces or any other owned by the central government. We cannot get information about any of this. The information you can get is about the public authority, that is the offices which is run or owned by the state government. So that is the three most important definitions. So the three most important definitions, as I told you, are interrelated. So these are important. And how do you get the information from the public authority and the grounds in which they can refuse information and how will they be penalized. So these are all some of the important things regarding this lesson, and I hope you have all understood that. So understand these definitions and understand all the procedure for the supply of information, which is very important. I hope you have understood that. Thank you. Have a nice day.